No one likes to get stiffed on the bill. And for lawyers, that can be a big problem if you're billing hourly and in advance. And so if you do the work and then expect payment from your clients, you may be in a situation where you'd like to fire the client and withdraw because you recognize you're not going to get paid. So I want to talk about a couple considerations to keep in mind in these circumstances. First, there's just prevention. How can you avoid having clients who get in arrears? Flat fees paid up front are one option. Personally, I really like that option because it takes the whole billable hour out of the equation, which just makes for a nicer attorney-client relationship. They know they can call you, they're not going to get billed for 0.1 hours, you're not worrying about tracking every moment. You still should track your time on flat fees, by the way, but it's not nearly as critical that you have every moment and that you're being completely fair to the client at all times in the time that you're tracking. If you can't be paid upfront on a flat fee basis, consider getting paid upfront on a deposit basis. You put the funds in your trust account and you hang on to them and bill monthly. And you can either withdraw the money out of trust to cover the bill or bill the client and still be paid with the money being held in trust the whole time as a safeguard against either the last bill or a bill that they don't pay. Another consideration is to bill more frequently. If you have a case where there's a lot of time being put in and the bill is rapidly getting large, consider sending a mid-month invoice to the client. Get paid then. Make sure the client knows just how big the bill is getting. It might inform some of their decisions, especially if it's litigation-based. But let's say you get to the point where, for whatever reason, the client has not paid, you're now in the hole quite a bit of money, you're not thinking that you're going to get paid anytime soon. How do you get out? You've got to look at your state rules because every state's going to be a little bit different. But in general, if you're in court, you probably need court approval to withdraw. And if you're not in court, you don't need court approval, but either way, you still need to make sure you're protecting your client. You can't just throw up your hands one day and walk away and say, I'm not helping you because you haven't paid. If there's a court hearing the next week or a transaction closing and you just walk away, you're probably violating one of your rules of professional conduct. But you can take steps to make sure your client's not prejudiced. You need to give them advance notice that you're going to withdraw. And if you're in litigation, seek their consent. Ask them to sign a substitution of attorney and let you out. If they won't, and you're in litigation, you have to inform them that you're going to need to make a motion to get out. And making a motion is bound to let the other side and the court know that something's wrong here. And a lot of people are going to jump to the conclusion that they're not paying their bill. So some clients will sign the substitution just because they don't want that being known. In transactions, it's less obvious because you're not having a substitution to file in court, but still, they'll often say they'd rather you not make a big fuss about it with the other side of the transaction and that they'll simply let you go and represent themselves or substitute you counsel. Now, for the procedures you need to employ, you're going to definitely have to look at your local rules. The state rules in general for the ethics rules, and sometimes there's going to be court-specific rules as well. Now, when you terminate the relationship for non-payment, keep a couple things in mind. One is that client is not going to be very happy with you, and there are concerns about how the relationship is going to continue to sour after you no longer represent them. This is particularly true today with online reviews being so prevalent. We would like to keep a client relatively happy when we terminate the relationship for no other reason than to keep them from going on a rant online about us. We don't need the headache of negative online reviews. That can be the topic of a whole hour of discussion of how to deal with them. But best to simply keep that relationship as congenial as possible as you withdraw. Another consideration is, do you want to pursue payment for what's owed to you? I'm not saying you didn't earn it, but pursuing payment comes at its own cost. Certainly suing a client for fees is an issue, because if you look at your malpractice insurance form when you go to apply or renew each year, they ask you whether you have sued a client for unpaid fees. It's a malpractice risk. When you sue for unpaid fees, there's often a cross complaint back against you for malpractice. So consider that. The best practice is just to do everything you can not to allow a client to get too far behind. And if you'd like more information about terminating attorney-client relationships and steps you can take to protect yourself from non-payment, see the article linked below in the notes.